Hi, this is Fred Neiman of Hanlon Neiman, practicing estate planning and asset protection in all 22 counties of the state of New Jersey. I want to talk to you now about blended families. In other words, families that are the combination of two parents, generally the result of second marriages. There's probably no topic more controversial and more charged in client meetings than when I am discussing estate planning with couples who are in second and sometimes even third marriages. When there are children born of different marriages, the issues become very complex. It's important to realize that under New Jersey law, there is no statutory right for your children to inherit anything from their parent. Therefore, if one were to treat their estate planning as if their children were to receive something under their will, in the absence of a specific designation, those children will not necessarily receive anything. But more troubling, and the issue of greater concern, in my opinion, is when in a second marriage situation, the spouses leave everything to the other spouse with the expectation or verbal understanding that the surviving spouse will do right by the children of the first departed spouse. And the answer is not so, or at least not so all the time. Probably the most controversial and emotionally destructive fights that I've experienced in the probate and estate litigation area has to do with blended families and children of different marriages. If you are a parent and you're concerned that your children receive something upon your death, you need to be very careful that you structure a trust or you make provisions in either your will or through beneficiary designations to ensure that your children receive something. If you leave everything to your spouse, there's nothing legally that can impede them from changing their will after your death and disinheriting your children. For whatever reason, I have found that relationships between stepchildren and stepparents often are strained or at a best description are not close. And upon the death of the biological parent, the relationships really change, generally for the worse. Depending on when the step-parent entered into the relationship with the children, the emotional attachments often are different. And so I would encourage you, if you have children of a first or second marriage, if you're talking to your spouse about how to protect both of your sets of children, come in and see me and let's talk about it. There are simple, easy ways we can make sure that your children receive something, but do not just assume that if you leave everything to your spouse, your children will be taken care of. It is probable that they will not. In our next video, I'm going to talk to you about the importance of titling assets in either a will or a trust to further your New Jersey estate planning objectives.